I think that it might.
which is um, Heath versus the People, number 9 of 2020. And for that, we have Attorney Marshall A. Webster, Sr. for the appellant, and from the Attorney General, Ian Stephen Anthony Clement, Esquire. So, Attorney Webster.
Yes, good morning, Your Honors. Good morning, Justices. Attorney Marshall Webster on behalf of the appellant, Mr. QUANZA HEATH, in this case. I'm not going to recite the facts, but I want to focus.
Do you wish to reserve any time for rebuttal?
Yes, I'd like to reserve 3 minutes, Your Honor.
Very well.
Yes. Okay. This case, I would like to focus, and I rely principally on the submissions that we made, but I would like to focus my argument mostly on the suppression issue, justices. In this case, you have a situation where the defendant, Mr. Heath, was on house arrest, and the police officers, together with the Superior Court Marshal, who was his manager, came to Mr. Heath's house around 10 o'clock in the night, knocked on the door. Didn't wait long. It was 10 o'clock in the night, knocked on the door. The police said they was under some operation where they were checking on people who were on house arrest, fitted with a monitor. They went to a number of houses that night, and they searched people's houses according to them and their yards. In this particular case, they knocked on Mr. Heath's door. Mr. Heath's uncle, well, that's 2 to 3 minutes after they knocked on it, he opened the door. However, the law enforcement officers went into Mr. Heath's backyard and they discovered some marijuana. And according to them, after discovering the marijuana, they spoke to Mr. Heath's uncle, who supposedly signed a consent for a vehicle search at the wrong property address. Anyway, they waited for 2 other police officers to come. I believe one was Mr. Detective Walcott, who came, and they said after receiving the consent from Mr. Heath's uncle, began to search the house. However, Mr. Heath was never a part of the discussion about the consent to search. This was not a consensual confrontation for Mr. Heath. He basically was not arrested, but seized in his home. There's a difference between an arrest and a seizure, but nevertheless, even a brief encounter.
Attorney, let me ask you the question. Mr. Berkeley, the uncle who was the custodian for Mr. Heath, he was the one that told them, that gave them permission to enter the place, and he was the one that I understood, even though it's the that signed the consent to search, even though we never see the form, the consent to search in the record submitted to us, but he was the one that gave consent. Did he have any standing as an occupant and living there, and one of the 2 occupants of the house on a regular basis to give consent to search the house?
Let me say first, he was not Mr. Heath's third-party custodian. His third-party custodian was the owner of the house, who was his grandfather.
Okay. Right, who was the grandfather. Okay, right. But he's there, and Mr. Berkeley and him are the only 2 occupants.
Right, he's also an occupant.
Except when the sister came from New York for Christmas with her 3 children.
Right.
All right. Okay. But look at it this way. The police officers, along with the marshal, had a right to approach that house, knowing that he was on pre-trial release and had the anklet. He was on electronic monitoring. Did they have a right to go there to find out if he's in the house where he's supposed to be?
I would say that the marshal has a right to go there, but the police cannot use a crime.
Well, remember now, it was a joint operation. The police
Judge,
is
I
giving
think
assistance. The police is giving assistance to the marshal because
that's
they
not
went
true.
to several homes at night. This is the last home, and therefore they went there. But
That's not
when
true.
they went there and his electronic device, which was given to him by the court to track Mr. Heath, he said, wait a minute, Mr. Heath's supposed to be here, but nobody is responding. And then there was a light in the house. So by this time, an officer went around to find out why is it that there's a light in the house and nobody's responding. And then this officer, male or female, whoever it might be, came upon the 100 plus, I think it was 114 marijuana trees in full blossom with lights and a whole elaborate system going on. Now, wouldn't that prompt them to run back and ask him? And he immediately said, it's all mine. He said, the operation you sit behind it is but for personal use. 100 plus marijuana plants for personal use. Now, but then they asked him about the search. And remember, didn't he sign it? Didn't he run back to the car to get a consent form and he signed it? Before they entered the house?
I think Mr. Buckley did sign a consent form that based on his testimony, he didn't know what he was signing, but he did sign a consent form. But even if you want to say that was a good consent, he can't give, when Mr. Heath is there, Mr. Heath is the subject of why they come there. And first of all, it wasn't an initiative by the Superior Court Marshal. It was an initiative by the police department that brought in the Superior Court Marshal. And they said clearly why they have that initiative. It was a crime-fighting device because the year before, during Christmas, they had crimes. And they specifically said the reason why. I don't think
my exhaustive reading on the record doesn't support that at all. My understanding is he is on pre-trial release. He has the electronic device on him, and the marshal, the police were assisting the marshals, the one marshal in terms of hitting all these places, whoever all that night was on pre-trial release with electronic device. But when they went there, all right, they went into the house, but all this time he's in there. Did he say anything to the police officers? Did he object to the search? Did he raise a ruckus about the search? Did he tell him to get out? Did he tell him anything at all during the interaction with them?
I think he was seized, and at that point, when he was seized, he was in a position where he had nowhere to go and nothing to do. I mean, when the police confronted him, it's a confrontation between him and the police. All right, and again, I would think that the marshal was assisting the police, not the police assisting the marshal. But anyway, the confrontation with the police, he had nowhere to go.
Attorney, a confrontation presupposes there is something that that there might be some sort of disagreement, something contentious, or sometimes like getting ready for fisticuff or something. But the house, as they went down the hallway, he's there to the one door, and they asked him, can we which room can we search that room? And he gave consent to search that one. Remember?
You don't have consent.
He said, go right ahead and search.
Yeah, but
he know they were going to find some female apparel in there. But
you know, when the violation occurred, which is the seizure occurred, when they entered his house and they put him up and say, stay here and you can't go anywhere, and where is your room? You have an encounter. You know, it's not a conflict. That's kind of like encounter. It wasn't a voluntary encounter.
He was there because he had to be there. That was the condition of his pre-trial release.
Of course.
To be at home during that time. So they did not confine his movement outside of what was best for him. But he could have moved about the house, but he could have go out on the porch, he could have go in the yard, but he stayed there. And then he said, you know, when they smelled the marijuana, he said, well, I just had a little smoke. And then they look across the window, they look across into the room, and they saw a lot of marijuana on the table. Somebody's definitely, something is afoot with the use of this marijuana. But that was in plain view, wasn't it?
No, not inside your house. And again, it was an encounter. He had an involuntary encounter with the police in his home, which constitutes a seizure. And is not an arrest necessarily.
He
but it
was
constitutes a
still
seizure.
around that house.
Attorney Webster.
The only reason why he couldn't leave is because of what was beneficial to him. He was on pre-trial release with an electronic device.
Okay, Attorney Webster, this task force operation, is it correct that the written agreement was prepared by the police and signed
Correct.
only by the police?
Correct?
Was
Correct.
there any signature by the marshals to jointly be involved in this?
None. One marshal was there. That's the marshal who's supposed to be in control of my client. And that was
Okay, when they approach the house and the marshal's records, his cell phone shows that the defendant is in the house where he is supposed to be,
correct.
what is the reason for going, for knocking on the door? To just verify that he is there?
Judge, if you look at the whole scheme of things, what's going on here, these police testify that they just came from someone's house and they did the very same thing. They searched the person's yard and searched the person's house. So they come with the intention to conduct a search.
And where was the monitoring equipment in Mr. Heath's house?
Right at the front door when they got in. That's what Mr. Richardson said. Right at the front door. They haven't articulated any reason for going beyond his door. And then they're searching under mattresses. I mean, they haven't articulated any probable cause for such.
Yeah, but that was after he agreed, he consented, right?
My client never consented anything. My client was...
He signed a release. He signed a form.
That was Mr. Berkeley. That was another occupant of the house, not my client. My client never signed anything. Only thing that my client did, according to Police Officer Walcott, was that when he asked my client which room belonged to him, my client pointed to a particular room. That was it. And but again, at that point, my client had an encounter, an involuntary encounter with the police, which means even if it was very slight, it's still under Terry versus Ohio, it's still a seizure. And so there was this involuntary encounter was a seizure. So when you're asking him questions, then what is the reliability of such? And then they can't articulate a reason why they suspect that he's involved in any criminal activity when there's no evidence of it, and they're conducting a complete search of his house under beds and all kinds of things. And just and this is in his home. This is not in his car or on.
Yeah, but if Mr. Berkeley had the authority to give consent to search the home, it was the whole home.
Judge,
then
my client is a grown man. He's been charged with a crime. Mr. Berkeley cannot have the consent or cannot give consent.
He represented to be his third-party custodian without any objection.
He never said that. We will never find that in the record that Mr. Berkeley ever said he was my client's third-party custodian. You will never find that anywhere in this trial record, the suppression record, or any record, because he's never been admitted. He never claimed to be my client's
brother, it seems to be cutting you off. So do you have a question before we?
I'm sorry.
Yeah. What about the apparent authority doctrine? Why was it unreasonable for the officers to believe that the consent being given by Mr. Heath's uncle was a good consent?
2 reasons, John. Let me explain. For one reason, that Mr. Richardson, who is his marshal controlling him, who testifies he's been to that location on more than 2 occasions or at least 3 occasions, have never seen Mr. Berkeley there. And as the person who's controlling him, he want to know who his third-party custodian, and he should know who his third-party custodian is. And he's never seen Mr. Berkeley there until that night. Secondly, what was I going to say?
But does that help you, the fact that Mr. Richardson had never seen him there?
Well, I'm just saying that's one reason. And then the next thing is even if assuming the apparent authority argument flies, it's still Mr. Berkeley wouldn't have the apparent authority to give anybody authority to search Mr. Heath's bedroom or personal effects. He could give him authority to search the general location in the house, like areas that they share, but stuff that is personal to Mr. Heath.
But is that the law?
That's the law, Judge. That's the law. That's the law. If your husband and wife is share common area is different. But where these are then not husband and wife.
Attorney, two questions.
And specifically the officer.
Just wanted to ask you a question.
Attorney, was there any limitation on the search that he signed, the form that he signed, saying that he could only search the kitchen or bedroom or otherwise?
No, Mr.
No, okay,
Buckley,
good, okay.
Mr. Buckley is the one that gave the consent, not my client.
The second question is, did he claim any ownership or any use of the bedroom in which the guns and the marijuana were found, where the guns were found under the mattress? Because he had already told them, this is my room here. And when they went in there and they looked and they found nothing but ladies thing, but he never did say, so he told them the wrong room might be his. But when they went over to that room, there are two things that came up. When they asked him to put on a shirt, he went in the dresser in the room where the marijuana was and where the guns were found, and then they found a document in there. But he never did tell them that that was his room. So they didn't need permission from him to search that room, because he in essence, by his response,
I would say,
it says he disavow any ownership of that room where the things were found. He can't have it both ways. He can't say that they infringe on my rights because I was occupying the room, and at the same time tell them, no, the other room is actually the bedroom that he uses.
Okay, thank you, Attorney Clement.
Good morning, Attorney Ian Clement for the people, Your Honors. We say the Operation Curfew was definitely a legitimate law enforcement objective. The marshals were checking on individuals who were on pretrial release. It is true that the police were there with them, but they definitely were there to check on pretrial release individuals. In fact, it was Marshal Chris Richardson who was the person knocking on the door at this point in time. Now, they showed up at 10 o'clock at night, at a point in time when you would expect someone to be home, because their purpose was to make sure that the people on pretrial release were where they were supposed to be, and that is at home. Now, when they get there and they start knocking on the door, and it shows that he should be in there, and they hear rustling inside, there's a light on inside, but no one's coming to the door for 3 to 5 minutes. They send someone around to the back, and you will see that on page 528 of the record. Now, Officer Fraser Jacobs goes around to the back. Her path to the back is unimpeded, and incidental to her trying to make contact back there, she finds some marijuana plants. She calls out, she's found something back there. By this time, Berkeley has come to the front door. She comes back to the front. So, based on the knock and talk doctrine, that incursion into the backyard was lawful. Now, when they ask Mr. Berkeley, talk to Mr. Berkeley, he says he is Mr. Heath's third-party custodian. He says that he owns the home. And you can find this testimony on page 651 of the record. They say, were you there to discussing with third-party custodian Mr. Heath? Yes. And did Mr. Berkeley give an answer? Yes. Were you there? Yes. What did he say? He said he was a third-party custodian, and he represented himself to be that. So that is clearly there in the marijuana. They ask if they can search. They get a form. It's a car form, but they doctor it to make sure to make it look not doctor it, but they change it so it's a house form. And they explain to him, Mr. Berkeley understands English. He understands the form. He signs it. They wait until he signs the form before they go inside. Now, once they go inside, once he's given consent to search the entire home, including common areas, but not areas of control of Mr. Heath as a co-tenant. And so they ask Mr. Heath, where's your bedroom? He points to a room. They go into that room. It's a room that contains female clothing. There's nothing in there. Coming out of that room into the hallway, they smell a strong smell of marijuana.
Just to be clear, you said they asked him that he gave consent for the common areas, but not for Mr. Heath's room?
Well, no, I mean, the law would be as co-tenants that he could not give consent for the areas under the control of Mr. Heath. So he gave consent, just a general consent, but Mr. Heath had the opportunity to prevent them from searching the areas under his control. And they asked him, where's your room? He points to a room. Can we search? Go ahead and search. They go in, they search. They find nothing. They come out of that room. They smell a strong smell of marijuana. They see a bag of marijuana on a surface in another room. They ask him about that room. He says,
Yeah,
I don't know
before
who
you
owns that room.
Why were they at the property? You seem to rely on the knock and talk doctrine,
Yes.
but you claim that you were there pursuant to this joint task force that gave the marshals the right to check on pretrial release persons that were on electronic monitoring.
Right.
So were they there to check on the monitoring, or they just happened to be the knock and talk, that they have a right to go up to any house and knock and talk? What was their purpose for being there?
Well, the initial purpose was to check on pretrial monitoring. But when you go around to the side of the house, I think that the knock and talk doctrine comes into play.
You had the testimony of at least one officer that clearly said their purpose was to go and search the premises of these pretrial release persons. That was their purpose. And when they got to the door and they knocked, within seconds, the supervisor directed the officer Fraser to go to the back. If they are there to find out if the person is inside and the GPS, the electronic monitoring, indicate that he is in fact inside, then what is the purpose of going around the back? To make sure he doesn't sneak in?
Well, the actual testimony was 3 to 5 minutes that they were there at the front door.
I know it said 3 to 5 minutes, but it also says that he didn't answer right away, and the officer directed Officer Fraser to go to the back. So it seems to me like they didn't even give the person a chance. You know, you assume people are sleeping at 10 o'clock at night. They said they could see the lights in the house, and Mr. Buckley came to the door, and he asked for QUANZA. He used a different name. He called out QUANZA. QUANZA came. As long as they saw he was in the house, you know, he had his electronic monitoring on. What is the purpose for going inside?
Well, they asked, well, first of all, Your Honor, based upon the timing of the events, it was 3 to 5 minutes before they made contact at the front door. Because at the point in time that Officer Fraser Jacobs said she found something in the back, that's when Berkeley comes to the front door.
Yeah, but he came to the door. They asked for QUANZA. He came out without a shirt on, I guess, and they could see that he is in the house. Isn't the purpose of the task force satisfied?
Well, they asked Mr. Berkeley if they could search, and he gave consent.
Well, let me ask you this, Attorney. To what extent? Because they knocked more than twice, possibly 3 times or more before anybody came out. And they had reason to believe that people were in the house. That's why the one officer went around in the back, where she encountered this operation of the marijuana trees and everything. Then when they came around, by that time, Mr. Berkeley had come out onto the porch and were conversing with the officers. But here is the key. When officers come to a place and they see something like 100 and something plus 140 marijuana plants right then and there, I mean, isn't that speaks of some sort of illegal activity going on when people are growing marijuana? They have their lights, the fluorescent lights and everything, are really elaborate operations. And they asked him, and he said, well, it's for my personal use. Well, at that point in time, isn't he committing a crime by having all this marijuana in the back growing? Where they have a right to say, well, you know, can you give us consent to search the house? Because this is no small operations here. So he gave consent in writing. They go into the house, they encounter Mr. Heath, and they ask him, which room is yours? And he said, this one here. And they asked permission to search that room. He said it's his. And he said, go right ahead. He did say words to that effect according to the testimony. So when they went in there, when they found all this female paraphernalia. But when they step outside from that house, well, I mean from that room, immediately or directly across, according to my understanding, there is the door open to that other room, which he disavowed that he has anything to do with, but there's marijuana on the table. He even said, I was just smoking marijuana because they smelled the marijuana. So they went into that room, the marijuana is in plain view, and then they said, gee, you know, and that's when because we still have the search where he gave consent to search. And unless I don't believe that he had limited to just a hallway or to any particular room. You give a consent to search a house, is a whole house, unless you qualify it. And he never did qualify it.
Attorney Clement, if a defendant is arrested, charged, appears, have a lawyer representing them, and they're released on pretrial release on house arrest, and in the custody of a third-party custodian, can the police then approach that person again that they know is represented by a lawyer and just go up to the house and ask to search the house?
Well, they have to. The individual has to. The police have a right to make sure that the individual is complying with the terms of the pre-trial release order, and that
The police have that right?
I'm sorry, not the police, but the marshals. The marshals have the right.
Okay, when the third-party custodian, gives permission for this person to live in their house, does the third-party custodian give permission that the marshals with 9 or 13 police officers can come to their house anytime at night and just break in and ask to search?
Well, they didn't break in and ask to search, Your Honor. They knocked. They came. They checked the equipment. They knocked on the door. They waited for a response.
If they were coming to check the equipment, once the person is in the house, that is the purpose. He is supposed to be on house arrest. He's supposed to be in the house. He is in the house. The equipment is right in the front of the door. The marshal can check it. He could check his ankle to see that the bracelet is on. Is this whole operation where the police officers can use the marshal? Does this sound like a subterfuge to you to get into this house and such?
No, Your Honor. No, Your Honor. Because in this particular case, by the time they're inside the door, they found a substantial amount of marijuana on the side of the house, in which Mr. Berkeley has claimed ownership of, and they asked Mr. Berkeley if they could search. They didn't ask Mr. Heath. They asked Mr. Berkeley.
But what authority is there for the police to go around the house if the marshal is there at the front door knocking to wait for the person to respond?
They have the authority under the knock and talk doctrine. They can go around to the side of the house the way any other person could, if they think that they can make contact.
The police officers or the marshals? The marshals are there to check on a pretrial release person. You're saying that you can bring marshals and tell them go around and search and then come back? If you find anything, then come back and we'll use that as a basis.
Well, no, that's not what they were doing. They were there going around the back to try to make contact. That was the entire purpose. And that's while there was a police officer around the back, she was just only assisting the marshal in trying to make contact with the people inside. Now she goes back there, incidental to her trying to make contact. She sees this quantity of marijuana. She calls out. She tells them. They come back to the front. By this time, Berkeley's at the front porch. They ask for consent. He gives it. Now they're inside the house legitimately, and he's consented to the
attorney. Let me ask you this question. A defendant cannot dictate or determine for the government how many people or how many police is going to assist a marshal. Remember now, they said that this was the last house for the night. So they went to several homes. Some of them might have been larger. Some of them might have been smaller. But when you're going to visit people at that hour of the night and whatnot, what is wrong with carrying with a police officer, several police officers assisting the marshals in going there? Because I thought it kind of curious to have a marshal with one sidearm alone to go to visit these people in the nighttime. And given the atmosphere now, that's a pretty sticky thing. But anyway, they go there and they encountered him, and they were once they knock on the door and they know that somebody's inside there, but nobody wanted to come out. Nobody's, in other words, there was no verbal response. Nobody said that they get a verbal response from within. They went around, and that's when they determined that there's movement in the house. So people are inside the house, and there was a light on. But they only know that because they went around and saw it. But nobody in the house said, "Hold on, I'm coming. Please wait. I'll be there." Nobody responded to them.
Yes,
Finally, Mr. Berkeley emerged from the house, came outside, and by this time they have discovered the marijuana. He said, "Well, that's all mine." But gee, at that point in time, do they have not reason to believe that there's something afoot inside their house with that amount of marijuana that they have found? I mean, who goes around having 114 trees?
Yeah. Attorney Clement.
Yes, sir. Yes, Your Honor.
The officers showed up late at night, 10 o'clock at night.
Yes, Your
Right?
Honor.
The testimony seemed to be that there may have been 4 marshals and 8 or 9 police officers, right? Some of them with long guns and right. Is that the kind of force that you go to check on whether or not someone is in the place where they are, where your evidence show that they are, and where they're supposed to be? Does that seem like a reasonable operation to you?
Well, I would defer to law enforcement to decide, and I think the court should also to decide what they need to do to keep themselves safe. You know, if they feel that they need
that's the kind of force you use with a knock and talk.
Well, you don't know what you're going to encounter, Your Honor. You have no idea what you're going to encounter.
But then why go? The idea is that if you you go to the door and you knock, and if the person comes, you can talk to them. It's not as if you have a right to go in and search the house. You know, this is all warrantless action.
But one of the things here is that, remember now, this wasn't the only house they went to that night. So several officers came.
I think that makes it worse. That's
several houses. This just happened to be the last one on their checklist for the night. This happened to be the last one, and
Yes.
and they have a right to. There's also something too. It has been known for people to disable those things and to be outside, and left the premises, but left the anklet right there inside the house. So you want to see a real body when you check in on people to find out if they are where they're supposed to be. You can't rely on that anklet or that bracelet because the telephone, your GPS, and when you put in the numbers showed up that yes, the anklet bracelet is in there. What's wrong with him? Because we have had instances where people have disabled those things that be out having a good time, like Good Time Charlie. So,
yes,
you know, so you want to see the person, and you stay there until the person, if they're inside, they must either have a verbal utterance or something to show proof that they are there along with where they're supposed to be. That's the whole idea. You're checking for a body. You're not checking for the contraption that they're supposed to be wearing.
But in this case, you know, usually when there's someone tampers with it, the marshals get an alert. There was no alert here. The records show that the officer using his phone knew that the person was inside. When they called him, so Berkeley called him. He came out, basically half dressed, so they know he was there. And then this whole idea of getting consent and entering and searching the house came after. But that's neither here nor there. So let's, your time is up. So let's go to Attorney Webster. You got your 3 minutes to.
Oh, I can't hear it.
Unmute yourself, Attorney Webster. Unmute your mic. Yeah, unmute your mic.
I apologize. I gotta get accustomed to this. All right, sorry. The touchstone for Fourth Amendment analysis, Your Honors, is for search and seizure is reasonableness, and whether the police acted reasonably. Now, They come to your house 10 o'clock in the night. If you knock at someone's house 10 o'clock in the night, you got to give them time to answer. I mean, that's common sense and that's reasonable. Okay? If the person take 2 minutes to come, you got to give them time. No, a police officer Fraser said it was 2 minutes knock, and her supervisor, who is Mr. Matthew, the police officer in charge of the whole operation, he told her, and she said this, testified to specifically, he said to search the place. He didn't say to go and see if anyone is in the back. He said, search the place. And she said, she looked through the window, and they could see lights and they could see movement in the house. So they didn't even get to the back of the house. They went further. After seeing the light and seeing movement in the house, instead of going back and seeing this movement in the house, they went further because they were instructed to search the place. And that's what they went to do.
Yeah, but attorney, that knocks out your argument that at 10 o'clock people might be sleeping when in fact they saw movement in the house and the lights.
Well, of course, they're knocking at the door 2 minutes after, there's going to be movement because someone is knocking at your door. So you come over of your sleep, but that person at the door knowing it's 10 o'clock should, and it's reasonable, and it's common sense to give you an opportunity to clear your brain and clear your mind to get to the door. Okay, because you don't know who's at the door. So you got to take, in the night, you don't run and open your door, people knock to the door. That would be unreasonable. That would be stupid to rush and open it because someone knocking at your door. The next thing I want to say, I was quoting Wyoming versus Houghton, is the United States Supreme Court 1999, is 256 US at 295. Also, the United States Supreme Court and well, let me say this, and United States versus Renford is a 2017 Third Circuit Court, and it was quoting Bostic, Florida versus Bostic 501 US Supreme Court 429. It says, a seizure occurs when taking into account all of the circumstances surrounding the encounter. The police conduct would have communicated to the reasonable person that he was not at liberty to ignore the police presence and to go about his own business. At that time of the night, police come into your house, 9 of them, and somebody line up inside your house. My client wasn't free to go about his own, he wasn't free to go back to sleep. Okay, so that was an involuntary police encounter, and court goes on to say that absent some exception, evidence obtained as a result of an illegal seizure, including evidence obtained by consent, tainted by the illegal seizure, is inadmissible. And we have the evidence tainted. When they went to the back of the house, that was an illegal search of the person, and they testified that this location
illegal search.
They had permission to search.
They went to look for someone.
They had permission to search. They were in the hallway. He directed them to the wrong room. While they were in the hallway, they smelled the marijuana. They looked into this other room. They saw the marijuana on the table, and they went in. It was in plain view, so they had the right to actually search it. And
yeah, the business.
So they were properly in that room.
The seizure according to no, I'm saying, Your Honor, when they went into that house and they seized my client, that's where the illegal and everything that comes from that is fruits of the poisonous tree, because my client was illegally seized.
Okay, well,
he was not free to go back to sleep. He was not free to do anything. He had to deal with
okay, just to wrap up, you agree that your client actually spontaneously asked the officer what was going to happen if his sister was going to be involved?
Yes, he did. He did. I agree.
So he started that, and you agree that that was not something that needed to be, Mirandaized before, correct?
Well, what the police said to him is basically that we're going to question your sister.
Right.
And
that was not coercive, and he voluntarily agreed, look, I don't want my sister involved, everything belonged to me, and he wrote out in his own hand that, okay, so.
Yeah, there's no custodial interrogation when they were.
I would agree.
The last thing I want to ask you before you go, on the speedy trial violation, in the brief, you use one sentence to simply say violated. You would agree that you waived that, right?
No, I would agree with that, Judge, because I don't have to put in my whole...
one sentence?
I don't have to put in my whole brief again that I wrote for the Superior Court, which is about what, 10 pages, 14
But
pages?
you argue on appeal. If you don't cite your authority and make an argument on appeal under our rules, you waive that. So
Yeah, but
okay.
but I know you would have granted me a speedy trial relief anyway. So
So you waived it.
Attorney,
Okay, thank you.
attorney, if that's not a waiver, nothing else is. You give,
Okay, thank you.
I've been reading the cases.
You
I've
give
seen
us
what-
one sentence.
I
One
seen but when
sentence,
one
attorney. And you
I
don't
haven't
tell
seen
us
anybody
anything
win
about
one
this
yet.
speedy trial. You don't
Okay,
tell us
thank-
about Wingo versus Baker, nothing at all.
Thank
nothing
you,
at all.
justices, for the opportunity to argue before you today.
Thank you.
very much.
The matter is submitted. So thank you both for attending, and